Welcome to the Divorce Podcast, where we explore all aspects of ending relationships, separation, and parenting apart. If your marriage or partnership has ended, or you have friends and family who are separating, this podcast is for you. I'm Kate Daly, a relationship counsellor, divorce specialist, and co-founder of Amicable, the online legal service for separating couples. In each episode, we look at relationships and separation from different angles, including the emotional, legal, and social. I'm joined by experts and special guests who share their own unique stories, experience, and tips with the goal of helping people end relationships in a kinder and better way. Nicole, the co-founder of Sale Homes and Sale Legal, and Edwina Davies, a licensed conveyancer with over 20 years experience and part of the Sale Legal team, to discuss the most common property and divorce frequently asked questions. Sale Legal and Sale Homes offer a fast and efficient conveyancing service for property transactions. And we start by exploring the impact property ownership has during a divorce and separation. We look at how property is treated in divorce, including options such as buying out your ex-partner, joint ownership, or selling and splitting the proceeds. We consider the various professionals you may need to use, such as conveyancers, mortgage brokers, estate agents, and even your bank, and which documents you need for buying and selling property during a divorce. Edwina and Jamie give great tips on stamp duty land tax and how to ensure you're exempt from the additional 3% levy. We also discuss the customer journey in a transaction between ex-spouses and how a separation agreement can speed up the process. Jamie and Edwina share the most common pitfalls and a few top tips for selling a property and explain how their expertise in dealing with transfers post-divorce can make the whole process a lot smoother and a lot quicker. If you loved this episode, then please subscribe and rate us on your preferred listening platform. Thank you both for joining me, and welcome to you both. It's lovely to have you.
Thank you very much. Lovely to be here.
Now, this episode is all about property and property on divorce. So we've got two brilliant experts with us to talk about some of the kind of frequently asked questions, I guess, around what happens when you're selling a property or transferring a property or remortgaging or any of the things that I guess happen when you're dealing with a divorce and there has to be a division of assets. It's just worth noting before we start, we've done a separate episode all about money, property, and when you're a cohabiting couple. So this really is applying to married people at this stage. So let's kick off with some real basic, simple ones then. Now, properties can be owned in different ways, can't they? So Jamie, would you like to just outline the difference between tenants in common versus joint tenants?
Yeah, of course. So with joint tenancy, both of you own the whole property essentially. So if one partner was to die, the other would automatically inherit the property. And this can be quite common for couples, but it can complicate things during divorce, especially if one wants to retain the property. The other way is tenants in common, and that will mean that each partner would own a share, and that would separately pass on in a will. And this gives a little bit more flexibility, but you need to agree essentially on what would happen with that share if you were to split or someone was to pass away. So usually this is something that people will be asked about when they're purchasing the property, and the conveyancer will go through the various options and explain what the pros and cons of each of them are. Not many people perhaps even know which option they picked. Sometimes there can be, extra fees incurred with doing a tenants in common situation. And so it's sometimes missed, but it's something that you can correct at a later date as well. But it can be very relevant to the divorce process, depending on which one it was done. And therefore, I suspect that it's probably one of the first questions that your divorce specialist must ask when dealing with a property.
Yeah, it's always one we ask, and it's always one where we get really blank stares. And I could never remember when I was married either how we owned property. It was just one of those things that you do at the time and then sort of forget. And I can't even now. I feel like it's one of those things that I should have tattooed somewhere because I can never remember which way round it is. So it's a really useful reminder. Thank you. So Edwina, you were going to add something then. Go on.
So when you own the property as tenants in common, the easiest way to identify how the property is held is when you look at the office copies, you'll see a restriction that we call a Form A restriction on the title. And it will say in section B of the register, no disposition by a sole proprietor. So that's the easy way to identify whether they hold the property as joint tenants or tenants in common. But one thing that is really important for this kind of matrimonial situation is that until the couple are divorced, if they don't have a will, if anything happens to one of the owners, the spouse, as the next of kin, automatically gets the property up to a value of 270,000. So it's really important that when people are looking to start their journey on separating, that if they're tenants in common, they need to make sure that something is registered on the title to protect them, to say that that's that. But also if they don't have a will, even if it's just the simplest of wills, the best thing that they can do is just to get a very, very clean will drafted up to say, I leave everything that I have to mum, son, whoever they want to leave it to if they definitely don't want it to go to their partner, ex-partner.
Right. Okay. Well, that's an important point because we've done a whole episode on wills as well, so you can find that one. And that we also, there's a company called Octopus Legacy, which is part of the Octopus family, of which our Amicable is a part as well, and they can do very cost-effective wills to that effect if that's something that people are thinking about or concerned about. So that's a good point. Now, you did say something which was it's the easiest way of finding, and then you said something that I didn't understand, which was the office copy. So just for people like me who perhaps aren't experts in this area, when we're trying to find out whether someone owns a property, tenants in common or joint tenants, what do we physically have to do? What's the office copy? Where do we get hold of it?
The first thing that you should do when you've bought a property, for the most part, I'd say like maybe 85% of land nowadays is registered, and that's registered with the land registry. So they will keep a public record of who owns what and how they hold it. When you've finished your purchase, you will get from your solicitors or conveyancers a title documentation form, and in it will say, congratulations, you are now the owners of insert address, and then you'll have your names in. So the register is split up into 3 parts. One is property, so it tells you the property details. Second is the name of the owners, that's the proprietorship register. And third is the charges register. They cost £3. You can download them yourself from the land registry if you have misplaced the copy that the solicitors have given to you. It's very easy to do. And like I said, if you just look in section B of the register, you will see your names. And if there is that restriction in there, or any wording that says no disposition by a sole proprietor, being no sale or transfer by a single owner, then you know that you're registered as tenants in common. The next thing you need to think about is, do I have a will or not?
Right. Okay. So essentially what you're saying is ultimately, irrespective of how you own it, if you're married, then that property is going to pass to your spouse unless there is wording or a will to say something different. So the whole point about this is it's irrespective of ownership, it's ultimately a joint endeavour, and from a legal perspective, it will pass to somebody who perhaps if you're divorcing them, you don't want it to pass to. So you should, at the earliest opportunity, get that sorted out. And you can change how you hold a property during a divorce as well, can't you? So there's nothing to stop you at any point, or even when you know you're going to separate before you started a divorce, you can start to change how you hold a property.
Yes,
ultimately,
you absolutely, yeah, you absolutely can. The easiest way or the most common practice is to sever the joint tenancy. So that will then create a notice that needs to be served, and that can be done by you as the applicant, or it can be done by the land registry when they receive that notice. And that will then enter the Form A sole proprietor restriction onto the title, thus giving you that protection that you want. You can also enter a matrimonial home rights notice onto the title. That will not tell you how the property is held. It's still going to be joint tenants if you haven't served that notice to sever the tenancy. But at least it means that if the property isn't in your joint names, it's perhaps in the sole name of husband, then they can't dispose of the property or do anything without first having a look and seeing what your interest in that property might be. Some people make both applications just to protect themselves, belt and braces approach. Others will rely on one over the other depending on what the ownership of the property is. But yes, if you are registered as joint tenants, you can sever that tenancy. It's not a complicated process. You can serve notice to your your partner or ex-partner, or the land registry will do it for you.
So it is really important, isn't it, if you don't own the property, to register your home rights so that, as you say, the property can't be sold from under you and therefore you become homeless. So that's a really important point, because we get asked about that quite a lot, where people are concerned that perhaps it's just been, that's how it's just always been, that for whatever reason, when applying for a mortgage or something like that, they just chose to own one person to own the property. It's really important the other person is protected in that scenario. So I can understand that.
Yeah, I mean, it was very common when I first started about 24 years ago. You'd have people my age whose parents would have bought in name of husband because he was the main breadwinner, and the wife was either a stay-at-home mum or worked home part-time. So that meant that the affordability aspect wasn't good for lending purposes. So wife would often not be on the title to the property. But then when things are not going well between, said couple, the wife's solicitors would ensure that matrimonial home rights notice was there, because people like me who are looking to remortgage or perhaps sell the property, we have to stop what we're doing and look and go, right, there is somebody here who is sitting behind the legal scene, the legal title, that has an interest that I need to investigate. And I can't just take husband's word on it.
And so what do you do in that scenario? Do you contact the person then? And what power do you have in that? What does the home rights actually do in that scenario then?
Well, the home rights notice, it triggers me as a conveyancer to actually do something, to look at something, to investigate what we call a beneficial interest in the title to the property is. I would, first of all, speak with my client, tell them that I found this and that it needs to be addressed, take their instructions. They may be very helpful and say, oh, yes, it was my first wife and so on and so forth. But you don't just leave it at that and ask ex-husband or ex-wife to sign the paperwork and everything's good. You have to contact that individual who has got that notice, because it is for their benefit. You need to verify their identity, make sure that they are who they say they are, and it's not the remaining owner's new girlfriend, partner, whatever, trying to, to imitate this individual. Normally, I always, as a matter of course, tell them that if they are no longer represented, they should go to a lawyer to make sure that they understand what signing this release form will be. And I also need to investigate whether or not there's any money that is still due. So, for example, a husband might have given a property to his ex-wife. The ex-wife couldn't afford to pay him what she was asked to in the court order because she wasn't financially able to at the time. Mr. will enter a matrimonial home rights notice onto the title, and he will only release that and give me the release form when I send to him the money that is due under the court order. And then obviously I will investigate who he is and then send him the money on completion.
So essentially there has to be a proper investigation then, and you have to get some kind of release signed from the person who's registered the rights. Okay. Then Jamie, what are the most common property transactions during a divorce?
So I guess you'll see most commonly selling the home and splitting the proceeds. You may also see one spouse buy the other out, or sometimes, you might maintain the ownership until a later point that sees fit. But I guess which option, will depend on the financial circumstances and if there's any children involved, of course. And so I guess that it must be quite an important part of your conversations with the couples when you're doing the work with them.
And are spouses treated any differently when they transact to an external buyer, seller or receiver when a property transaction is going through? So I guess what I'm getting at is, if you're transferring between spouses or you're selling and splitting proceeds between spouses, is the process different to when you're a couple and you're buying from an external person? Or is it just the same and it makes no difference that the transaction is happening between spouses?
The client journey should be the same. So the level of client care that you give, it should absolutely always remain the same. One thing that you have to be careful of as a lawyer is that you need to make sure that there's no conflict. So one isn't trying to side you off against the other. And for me, it's a very simple, you're open and honest at the beginning and say, look, I both treat you equally. When it comes to making decisions, you will both be asked for your input and, whatever requirements I need from you. You'll both be treated fairly, and your instructions must always mirror one another. So your completion date preference must be the same. You must both be in agreement that it's a 50-50 split or 60-40 split, whatever it happens to be. If we're doing a transfer, for example, are you agreed that this is the amount that you are going to be receiving for your share in the property? And are you happy to relinquish all of your interest with that? The sale part is slightly easier because you are representing both parties just from the point of conveyancing. We're not matrimonial specialists. But when it comes to the transfer, I always, like I said before, I'll always advise them to go and seek independent legal advice, because what you don't want is for somebody to come back in a few years' time and say, I was not fairly treated, I did not understand, I did not realise. But one of the things that I have found in working with you, which has made the transfer cases much easier, is that I'd say so far about 95% of the time there is a court order or a separation agreement that both parties have signed. And that's very clear then, because not only are both parties supported in this is what has been agreed by either the courts or by you two mutually, so that reduces that risk of somebody turning around in 2 or 3 years' time and going, it wasn't fair, it wasn't right, because there's a document there and all we're doing is transferring the title of ownership in accordance with both of their mirroring instructions.
Yeah. And Jamie, what do you think then makes sales so different, say, from dealing, because we've now got a partnership with you because we feel that your ability to deal with couples is, the best that there is. And that's what makes it work from our customers' side. From your side, what was wrong with the marketplace? Why did you come into this marketplace in the first place?
Thank you for the compliment. A number of conveyancers have done things, there's probably a lot of people listening now that have gone through the process of buying or selling a property and have probably, wondered why things were done the way they were. And it's quite an interesting industry that's it's struggled to innovate, that's for sure. I think particularly law in general has struggled to adopt technology in a way that makes the process easier. And so we found that when we really understand the needs of particular niches in the market, for example, people going through divorce, we can really understand the bits that hold the process up. And so when speaking to people going through the process and some of your divorce specialists, it was quite apparent that there's quite a few grey areas on what the process should be. For example, do you need a court order or a separation agreement to, complete a transaction? If someone's leaving the marital home and then purchasing another property, do they have to pay the extra stamp duty for owning a second home if the divorce hasn't completed yet? And these scenarios seem to be ones that you get mixed messages from across the industry.
Well, let's answer both of those because they are two of the biggest questions we get. So go on, answer those, because we get asked that all the time. So do you have to, if you are disposing of marital property or even doing a transfer or anything like that, do you have to have a consent order or a separation agreement in order for a conveyancer to process that request?
So you will, of course, a consent order would be the most solid document to be able to use. However, and particularly with people using your service, people, if they're in an amicable situation and they've agreed a separation, there's no reason why a separation agreement could be used in order to carry out that transaction. At the end of the day, like Ed was saying just a minute ago, it's about just making sure that it's absolutely clear that both agree on what the final divorce looks like and that we're avoiding any future claims. If everything's absolutely clear and everyone's in agreement on how that should separate, a signed separation agreement would be fine to use in order to carry out a transaction.
So I think the point you're making is then, from a customer or a consumer perspective, you will get different answers to that question depending on which conveyancer you are sitting in front of. So from our perspective, people who are looking to do this in an amicable way need to pick their conveyancing solicitor very carefully. When you are disposing of properties and buying other properties, or if you haven't quite disposed and the chain isn't quite running in the right sequence from you've only ever got one property on your books kind of thing, what are the rules around whether or not people have to pay the extra, is it still 3% on top of the normal buying costs? Just one of you explain that to people, because I think that's people get quite worried about this as well. It's a lot of money.
This is one of the reasons why I think people might elect to use a separation statement, if you like, and certainly a separation agreement rather than waiting for a court order. Because if you can get a separation agreement drafted by you guys and signed within, let's say, 3 weeks, I, at the same time, run alongside the transfer. I can do everything in my power to get that transfer of equity completed before the completion of the purchase of the other property. If we can run it concurrently and complete either the day before or on the same day, you don't have to pay stamp duty at the 3%, because so long as that individual, let's call it so long as that individual is releasing her interest from the former main residence and then moving into another property that is going to be her main residence, then she wouldn't have to pay stamp duty at the 3% or whatever the additional increments are, depending on consideration for the purchase. She wouldn't have to pay that additional higher amount. She'd be able to pay it at the normal amount. And all that would be asked of from me is just a copy of the transfer dated the day before, same day as, whatever, to submit to the conveyancing firm that is dealing with that purchase, so that they could then put on their stamp duty land tax form, she only owns one property and it's going to be this one that she's buying. If you can't complete that transfer and the disposition, whether it be by way of a transfer or sale of the main residence, isn't going to happen for some time, and that's because perhaps the spouse that's going to retain the property has got a bit of difficulty in trying to obtain a mortgage, let's say, then the buyer, i.e. person that's moving out, will have to pay stamp duty at the higher rate. But so long as they can complete the transfer of the former matrimonial or the former main residence, and that's the key point, it's main residence. So was that their main residence when they were starting this whole thing? If they can complete that within 36 months of the date that they complete their purchase, they'll be able to claim back the difference between what they should have paid as somebody that was buying a house just purely by moving home, and what they had to pay because they own two properties at the date that they actually completed the purchase.
Right. So if you can use a separation agreement to do it all very quickly and sort it out within a couple of days or a day, then happy days, you don't have to pay the extra 3%. If you can't do that, you've got up to 3 years where you will still have to pay it, but you can claim a full refund on that difference.
And to come back to your question earlier about, why did we go into this? I think these examples give you an idea for why, because it's almost like an iceberg. The experience might seem quite light when it comes to conveyancing and quite straightforward, but there's all of this nuance to particular situations like people separating that, when understood, it's not necessarily about us taking more risk in this area. It's about us understand the situation in such detail that we can actually help them to create a journey that suits both parties, because we totally appreciate that there's some bits you can't control, such as how long the consent order might take. And therefore, if we can make the transaction work to their favor and make sure that these things can happen in the right order, we can save them, a year, other than what would typically happen is you have to get past one hurdle in order to get to the next one. And so by being able to fully understand these problems well enough, we can actually come up with solutions that can actually get them the result that they want as quickly as possible.
Yeah, so that's the bottom line, isn't it, Jamie and Edwina? You understand the divorce process, which means you can make sure that you can go around the rules in a way that allows people to get the outcomes they need without breaking any rules, without doing anything that's not allowed, without putting anybody or the business at risk in any way. You've just got that deeper level of knowledge and understanding of divorce specific situations. And we know from our end, we get asked lots of questions about this, because people's main concern when they get divorced is where they're all going to live. Of course it is. So trying to make sure that you time the buying and selling and transferring of the properties so that no one's left homeless, no one's falling foul of any tax laws, everyone's paying the right amount of stamp duty or whatever they should be paying, and no one's paying too much and putting themselves in a situation where sometimes these margins are very fine in terms of just about being affordable. If you stick another 3% in sort of stamp duty on top of some of these transactions, they just simply fall over. So it's really good to hear that you've got this deep expertise, and anybody who is going through a divorce or separation should really be beating a path to your doors in terms of trying to make sure they've got conveyancers who understand exactly what the rules around all of this stuff is, because I know we find it really challenging at the best of times.
But do you know what? There's also, what in my experience, because I worked for a firm where matrimonial transfers was a huge proportion of our work for a very long time, is that the HMRC were actually really helpful. So when there was all the changes in the regulations with regards to stamp duty, and we've had so many of those changes, haven't we, with lockdown and the crash in 2008, etc. One of the things that I did was that I went through every single scenario that I'd experienced whilst I was at that place of work, and I submitted my questions to the HMRC and said, in this instance, would we have to pay stamp duty at a higher rate? This is scenario one. And there was like 10 scenarios. So the other thing is, I think that sets us apart is that we're not scared to go off and ask the questions, find out the information, and then apply that in how we do stuff. And of course, from a compliance point of view, you've got that letter from the HMRC that quite clearly says, this is the scenario. And in this scenario, the answer is no, you wouldn't have to pay it. And the other thing that I just wanted to say is that with regards to the separation agreement, if time is of the essence for you guys, and for you guys, I mean for couples that are separating, for the cost of a separation agreement that can be arranged as quickly as you guys do it, to mitigate against that period of 36 months where you would have to wait potentially to get money back from the HMRC. And it's not a difficult process, but it is a bit of a pain. It's worth the money. It's worth the peace of mind. It's worth the dotting all the I's and crossing all the T's, and you don't have to think about it. You just move on. You move on and you start afresh.
Well, that's the attractive thing, isn't it? Because in all of the work that we do, people are looking for that point in time where everything is done. It's like when you're building a house and you've got the never-ending snagging list, isn't it? And it's the same with divorce and separation. It feels like, particularly, when you do our process and then you still got to do implementation of the various agreements, it just feels like it goes on and on and on. So you're right. If you can have a document that actually says, you don't need to think or worry about this anymore, you don't need to pay the extra money, we've got everything sorted for you, you're shortening that whole experience by another 3 years, aren't you, ultimately, which is great, which is really good.
Totally. And when you're going through these property transactions, whether it be a transfer or a sale or a remortgage, there's always things that pop up related to the property when we're reviewing the deeds and we're reviewing the transaction. And so the earlier you can get into those problems, the better. So sometimes, we might have people that come to us very early on in the process and they haven't got a separation agreement yet. They may not have even decided on the separation completely. That's not a problem. We can still have a look at things. For example, when you're dealing with a leasehold property, there is, a couple of extra steps that usually have to happen, even if you're just transferring the property. And so it's important to sort of get an understanding of what steps are in front of us as early as possible so that we can then actually give you a sort of plan of action on what we need to do in order to complete this transaction. And leaving it until the last minute can sometimes bring up hurdles that you didn't foresee. And therefore you can add, a month or two on that we could have done adjacent to the divorce process.
What do you think are the most common pitfalls people face when they're doing, say, let's say, for example, a transfer. So let's say you've got a divorce going and wife is transferring her interest to husband. What are the things people need to be alive to when that kind of situation occurs?
I guess one of the first ones I would say is the finances, understanding what can be afforded, because sometimes it's probably not as simple on paper as to how much will be required in order to finance a buying out of a partner. For example, there might be things like early redemption charges on the mortgages. So, sometimes people might forget that, they might have just remortgaged last year. And in the small print, it might say that actually, you need to pay back 2%, 1% as a early redemption fee, so that when, you might then go and get another mortgage, but all of a sudden you've got an extra fee on top. So I think it's quite important sometimes just to get a spreadsheet out and figure out all of the costs involved, because sometimes I think they can sideswipe people. We commonly see people say, oh, well, what I'll do is I'll go get a mortgage to buy out the other partner. And when doing that process, you realize actually there's more costs involved than you might have first expected, or that you can't raise it enough, because very, very often mortgages for partners can be on really good rates, and sometimes it can be a lot harder to raise the amount of money needed for someone on their own, especially if it's all based on income. And so I think that's probably one of the most common pitfalls. It's quite common and understandable for people to start with the intention to buy the other person out, and then once you've sort of done the financials, realize actually maybe this isn't as affordable as expected, and then need to sell the property. So I'd say that's probably the number one thing to get going with as early as possible.
I guess from our side as well, one of the big pressures when you're doing the buyout side of thing, it's fine if you're selling, but when you're doing the buyout side of thing, it's valuation. Because obviously it's in one person's interest to have a high price and the other person's interest to have a lower price. So for us, that's always a slightly trickier one when it's a buyout. And I think you guys can help with that as well, can't you?
Yeah, so we've been doing valuations for quite a few years now. Again, really helping people in particular situations where the need for a fair and honest valuation can be particularly helpful. So, the two areas we work in quite a lot, and we work with Octopus Legacy as well, is in probate, where you need one for the benefit of working out inheritance tax, and exactly the same with divorce. You need to understand what is it actually worth. And there's definitely a difference between what an estate agent will tell you it's worth and what it's actually worth. And that's why you'll see quite a stark difference between going to, a chartered surveyor to say what's this worth and what an estate agent would say. And the reason for that is a chartered surveyor will have a particular process which is modeled out and, in the handbook that they all have, and it tells you exactly how to value properties. And a lot of it is based on sold data. So what did things actually sell for? So you may have a row of terraced houses, and on Rightmove, you might look at Rightmove and see that there's one for 300, one for 310, one for 325. And you can even switch on that little feature that says, show me the under offer properties. And then suddenly you realize, there's one for 320 that's under offer. Now, on average, estate agents will sell properties for 97% of what they're on the market for. So as a rule of thumb, you can sort of wipe off 3% of whatever it says on there. Now, that isn't a great way of valuing it, because it can massively fluctuate across the country. We're seeing at the moment that London is particularly difficult to sell. The demand's not there like it used to be. And in other areas, it's super hot. And so, the marketing price that estate agents go for isn't a very good indication of what they actually sell for. Now, Land Registry hold all of the prices that the property's actually sold for. So what you'll see a surveyor do in their reports is they'll put comparables, properties that are very similar that actually sold. And they'll use those numbers as a way of working out what it's worth. And that's a well thought through process. And those surveys usually cost between sort of £300 and £500. Now, other ways that people typically try and do it, and to save that money, is to go to 3 local agents, for example, and ask them to value the property. And exactly like you were saying, you very often see people say, well, you pick one, I'll pick one, and then we'll agree on one and we'll see what they all come out with. And it's really common to see prices fluctuate between, like you see ranges of sort of 100, 150,000. In fact, we're dealing with a couple at the moment that are breaking up, and they've had everything between 800 and 1.1 million. And it's really hard then to decide, well, who's telling the truth? And you don't really know until you go to market, unfortunately. But what you can do is you can make a calculated estimate you can use numerous ways of valuing. So you might use the sold data and say, well, what do things actually sell for? And then maybe you go, well, what does the current market look like? Because if things are going under offer quite quickly, you could be quite confident in the marketing prices in the area. All saying that, when it comes to us doing valuations, there's some fundamental things that really matter, and most of it is around sold data. A lot of it is around the condition and how big the property is. And these pieces of information allow us to be able to create a calculated number, which has some evidence behind it, which if HMRC were to challenge it, they would be able to see the calculations and go, right, fair enough, I can understand how you got to that number. And that's one of the pitfalls of using estate agent valuations, is very often they're a letter provided by the agent that says, thank you for showing me around your home. It's very lovely. I think we should put it on the market for £1 million. And there might not necessarily be the evidence behind it. Having said that, they're usually local experts. They do have a good feel for the area. They probably do understand, what is selling and what's not selling. But you just got to bear in mind that at the end of the day, they're incentivized to give you the number that you want to hear in order to get the instruction. And so, of course, they're not going to give you wild numbers that they don't think are realistic. But that's the reason why you can get such a fluctuation on the numbers so often. So usually you see people doing the 3 agent valuations. Probably the safest way is to get a survey, but there's probably somewhere in between where you can do an evidence-based valuation that the HMRC would accept. And hopefully, because of the fact that there's some logic behind that number, both parties can agree on as well.
So I guess you offer that, don't you? You offer the evidence-based valuation, and people can go to your website to find that. If this is an issue that people are facing, they want a fairer approach than doing 3 local solicitors, don't want to pay the expense of a surveyor, then you've got an alternative option.
Exactly.
And I'm just conscious of time. This is just so fascinating though. It's such a deep dive into some quite technical areas, isn't it? I'm just wondering, Edwina, are there other pitfalls that, if there are people listening to this who are separating and are at the point at the very beginning and they're thinking about, they're not quite sure whether they're going to have to sell, transfer, what they're going to do at this point, what would you say to them in terms of your top tips for dealing with property during a divorce or separation?
I think, do you know what? First things first is I'd speak to somebody about affordability. So go to your bank. What are your finances like? How much can you afford? I'd speak to a lawyer so you can get a bit of groundwork on what should I be doing? Where should I be looking? Do I need a matrimonial specialist? Who can I go to? I don't want to go to a traditional law firm. And I think that knowledge is power. You're going through such a really horrible time, and you've probably in the back of your mind got a load of sensible questions, but don't necessarily know how to articulate it. If it's your house, go and speak to a conveyancer, because a conveyancer will tell you this needs to be split into 3 parts. If you're selling, you need an estate agent. Let's find you an estate agent. And do you need a mortgage? Right, let's go to speak to your mortgage broker. Start off with your bank. That's going to cost you nothing. They know your affordability. Next bit is, are we selling? Are we buying out? What are we doing? And if you do need to go and see, and obviously go and speak to somebody like yourselves to deal with all the nuances and technicalities involved with the actual divorce itself. But in doing that, you can give them a very specific list of instructions that they can follow that can just give them some guidance as to what they should be doing, how they should be doing it, and feeling like they're getting a bit of traction and things are moving, despite the fact that they're going through this really horrible time. All you need, it's like when you've got a problem of any kind, isn't it? You go and speak to the person that you trust the most to hear you out so that your concerns are validated. And if they don't know the answers, just to nudge you in the right direction of who you need to go and speak to. So just make sure that you're clear in what you want to do, and before you sign up or agree to anything, that you've spoken to somebody in particular like you who can say, right, just hold off, don't do anything until this, that and the other. We need to get X, Y and Z.
Okay, that's brilliant. And Jamie, what about you? What are your top tips then if you're facing property issues during a divorce? What would you say to somebody listening?
I think it comes back to the financials. I know that there's nothing with a property that can't be solved with enough preparation time. So, the divorce process isn't going to happen overnight, and neither will either a property transfer or a sale. So the earlier you can engage with a property lawyer in order to help with that process, the better. But I think particularly it's the financials involved. It's not cheap to sell a property or to move home. And so, it's about just making sure you fully understand the wider situation. For example, if you are forced to sort of sell the main residence, the home that everyone lives in, there's costs incurred with selling the property, the legals, there's also moving home, stamp duty on the next houses, and therefore, that sometimes it's about just fully understanding the wider picture, because it can be quite a costly experience, and knowing what you can and can't afford, I think, is particularly helpful. And the sooner you can understand that, the better. And I guess, those onward costs as well have to factor into the discussions around the divorce as well, because it's not as simple as, we're going to sell the home and, maybe you've agreed on 50-50. I guess if there's kids involved, then sometimes, there might be more costs incurred on one side because they might need a larger home than the other, for example. And so I think the financials is really key. As long as you're engaging with a property lawyer as early as possible, any of the hurdles that can come up can be dealt with sooner rather than later. That's for sure.
And just to add to that, I think that the other thing that is really important is that when you're talking to these people, you as the consumer, not us as the lawyers or agents, be completely honest. Don't say things that you think are relevant. If the questions are asked, like, for example, how are you going to finance this transaction? Oh, well, I'm getting a remortgage. And I've had this on a couple of cases recently. I'm doing a remortgage. Brilliant. Do you know how much for? Can't determine that figure yet. Right. Are you paying ex-husband, partner any money? Yes, I'm going to pay them X amount. So you're like, right, okay. They're telling you doing a remortgage. They've not said that any money is coming from anywhere else. You get in the mortgage offer, it's for exactly the same amount as the mortgage that you're redeeming. And then you find out they're getting a gift from inheritance that they haven't had yet. And you now need to refer that to your lender because it's a loan, even though they say it's a gift. You need to do all of that. And whilst you're going through this really turbulent, or even it can be just emotionally draining situation, by missing something because it was in your mind either not relevant or none of our business or whatever, we've now added a scenario where you will get charged extra for the review work that needs to be done for investigating that source of wealth and source of funds. But also you're adding so much more work of back and forth in trying to put together a picture of what is actually happening, because you didn't say at the beginning, I'm getting an advance on my inheritance, which you could have resolved in 10 minutes on an initial call and, got all that out of the way, and that's it. Then that smooth, thing goes. What we truly want to do for all of our consumers is just to make their experience with us as seamless, as painless, and as stress-free as possible. And it's those little roadblocks that sometimes come in. And it's not, I don't think anybody ever does it maliciously, but it's just like, oh, I know that's going to ask a question and I can't be bothered to deal with it. It has to be dealt with. So let's get that all sorted right at the beginning. Let's not leave it until, the time that you actually want to complete, which then just puts more pressure on you. But source of wealth and source of funds is one of the trickier conversations that clients really don't like having a discussion about. And it's like, well, it doesn't matter. You're getting a gift from your parents. Fantastic. Lovely to be in that position. Well done. Brilliant. It's just so long as we're just going to ask a couple more questions and that's it. I don't have to disclose that information to the person that's being removed from the title to the property. It's none of their business. That's all you. That can all stay there. But in keeping that stuff back, it can make things a little bit more complicated moving forward if you're not as transparent as you could be.
So come to you early, be completely transparent. They're the two key big takeaways from this. I feel like we've barely scratched the surface, but I'm so conscious of time now. We've really overrun, haven't we?
There is one thing that perhaps your listeners might want to think about is that if you are in a position whereby you have separated from your former partner and now would like to add on your current partner to the title to the property, be prepared to experience some resistance because it's not great for everybody involved. But also that stamp duty exemption that we were talking about before, where it's Mr. and Mrs. Jones registered as the owner, Mr. Jones is going off to buy his own house, and Mrs. Jones now wants to add her new boyfriend on Mr. Smith, that will catch stamp duty if the consideration for the transaction hits a certain threshold. So if the consideration for the transaction is less than 40,000, you don't need to let the HMRC know. If it's over 140,000 and under 125, you need to let them know about the change of ownership. You can't rely on the Finance Act exemption anymore. And if Mr. is receiving money and Mr. Smith is giving money, as part of that, that all forms consideration. Consideration is made up of the assumption of debt and money that is changing hands. So appreciate that many people will have to add their new partner onto the title of the property, A, because they want to, but also B, from a financial perspective. But you need to be prepared for the fact that there may be stamp duty incorporated as a result of that.
And does that happen irrespective of how long after the original transaction? So the original sort of removal of Mr. Jones in that scenario, does it matter how quickly you move Mr. Smith in, or is there a point at which it becomes irrelevant?
You can move Mr. Smith in as quickly as you like, but if you are using that one disposition, that one transaction to take Mr. Jones off and add Mr. Smith on.
So it's when you do it at the same time, that's the issue.
Yeah. And the reason that you would do it at the same time, isn't it, is because Mr. Smith needs to come on because he's helping you out with the mortgage repayments for the foreseeable future. So in issues, again, in situations like that, and it depends on the monies that are moving hands and stuff like that, there is a company that is called SDLT Compass that can give you bespoke advice on that kind of thing. The alternative is that we can write to the HMRC with a specific scenario, because at the end of the day, stamp duty is a personal tax, right? So if you get, and we're not, tax advisors. So if you get it wrong and the HMRC give you a lovely audit, it's on you. But let's avoid that. Let's get this all boxed off for you. Let's get that letter if you don't want to go and pay for Compass to sort out your question. Let's get that scenario to the HMRC and ask them whether or not, this particular transaction would trigger a stamp duty payment.
That's brilliant. Thank you very much. Some amazing advice and guidance in all of that. Really appreciate it. Edwina, where can people find out more about Sale Legal?
Just Google us at Sale Legal, and we've got a really simple, comprehensive website. My details, I believe, are on there, telephone numbers on there. You can actually generate your own quotation for any kind of work that you want to go on there. But if you're not sure, then just call us and I can walk you through it. My team and I can walk you through it and make it bespoke to what your particular situations are. Or if you just need to speak to somebody for 5 or 10 minutes and just go, what do I do? Where do I go? Just call us up on the number on our website. We'll be happy to help.
Brilliant. Thank you. And obviously, if anyone who is an amicable customer is listening, then they can speak to their divorce specialist about how to get conveyancing help. The details are also on our website as well for anybody who is looking for a quote for conveyancing. And then, Jamie, what about Sale Homes then? How can people find you?
The same, salehomes.co.uk. They can very simply request a valuation through the website, and we'll go through all of those details. And that we are available on the Amicable website as well.
Fantastic. Thank you both very much for joining me. It's been a fascinating session with lots of detail in there. If some of that went over anyone's head, a little bit of it, I'll be honest, went over mine. So if any of that detail went over your head, these guys are very happy to speak to you individually and look at your bespoke questions one-to-one. So please do feel free to get in contact. Of course, you can find me on LinkedIn and hear more about new podcast episodes by subscribing for updates and visiting thedivorcepodcast.com. Or you can download us on your favourite listening platform. Thank you very much, both Edwina, Jamie, for joining me, and thank you, everybody, for listening.